Hello, good afternoon, everyone. My name is Alex Schwartz. I am Deputy Director of the Center for Comparative and Public Law here at HKU Faculty of Law, and it really is a great pleasure to be chairing this very prestigious panel here today that the Center for Comparative and Public Law has organized. So we have really two really great people who coincidentally, as a sort of happy cosmic coincidence, are in Hong Kong at the same time, both of whom have lots to say. So we're very, very fortunate to have Justice Carlos Bernal of the Colombian Constitutional Court here with us today. He's also Associate Professor at Macquarie Law School in Sydney. In addition to being a judge on one of the most highly regarded courts in Latin America, and I think also just generally in the world, he's also someone who's published a lot on philosophical aspects of constitutional law and rights. So he combines both a judicial perspective with a more philosophical perspective, which is a real treat to have that in one person. We also have, very, very happy to have Professor Alex Stone-Sweet here, who's a Centennial Professor of Law at the National University of Singapore and formerly the Leitner Chair of Institutional Law at Yale Law School. He's very, very well-known person in the field. I mean, I think it's probably not much of an exaggeration to say that your contribution to the literature is so big that it is the literature in some ways. So that's really, really a great thing that we have here today. And also, we're joined by two of my colleagues at HKU Faculty of Law, Professor Po Jin Yap and Cora Chan, who will be providing some commentary. So I won't waste any more of your time, and I'll let our speakers do the rest of the talking. So first we'll be hearing from Justice Bernal on the normative necessity of proportionality in constitutional adjudication. Thanks very much.
Okay. Thank you so much, Alex, for this introduction. And it is a privilege and an honor to me, for me to be here today with Alec, a person who I admire, and I think he wrote a wonderful book along Jed Matthews. Also, I would like to thank my host, David, who is in a plane, I think on a plane coming here, and also the students. We had a good seminar, I think, and then I look forward to your questions and then to the discussion on this panel. The title of my presentation is The Normative Necessity of Proportionality Analysis. The normative necessity of proportionality analysis. One of the core business of a court, like the court in which I work, is adjudication of constitutional rights. And then in the practice every day, every Wednesday we meet in a room a little bit smaller than this one. And then the question that we ask is how to adjudicate the cases, how to approach that adjudication of cases. And of course, there are many ways in which we can proceed. Sometimes if we are independent justices, we are just thinking about what is the best argument, what is the solution for the case. Sometimes this is not the case, and I have colleagues, and they are open about that. They have links to politicians and links to authorities that influence them to vote in a way. But regardless of that, we have to make a decision, and then to make that decision justifiable on the basis of the Constitution, justifiable on the basis of the Constitution. Now, there is a whole deal of implications about this justifiability of our decisions. The first one is the own survival of the court. Why? Because sometimes we as court, we face backlash. For instance, 3 months ago, we had an episode. I have to say I dissented that opinion, but the majority of my colleagues, indeed I was the only one dissenting the opinion, struck down a provision of drug consumption in public places. The legislature had enacted a law in which they prohibited the consumption of drugs in public cases, in public places, And my colleagues decided to strike down that provision because the provision was too general. Was a provision that made it impossible for one person, for instance, to consume marijuana in a public park. And then my colleagues thought that this provision was not compatible with a former decision in which the court declared that the consumption of marijuana was a legitimate form of exercise of the right to free development of the personality. In my case, I linked that piece of legislation with a huge problem that we're facing in Colombia right now, which is a micro trafficking of drugs. There are many drug dealers that just are selling drugs close to schools and trying to influence the young population in getting used to the drugs, and the government is trying to fight that phenomenon. And this law was part of that package. But of course, I understood the reasons why my colleagues struck down the law. The problem was that right after the decision, 2 days after that, some of the right-oriented politicians, they threatened to close the court. They threatened to close the court. And then, of course, my colleagues, they try to use proportionality analysis to justify the decision and say, look, we struck down this decision because the decision is too general. There can be an alternative option of regulation. That is to say that each mayor of each city demarcates some zones in which the consumption of drugs is possible, and then some zones in which the consumption of drugs is impossible at all. Now, here, this is just one example on how important it is for a court to justify the decisions. It's not only about what the decision is, but how to justify that decision. Now, there are many alternative ways to justify decisions concerning the adjudication of constitutional rights. One way, for instance, that is linked to the First Amendment of the US Constitution is the categorical way, which is linked to one famous doctrine that Ronald Dworkin made it famous, which is the idea of rights as trumps. It's the idea that in the Constitution we have some rights, and they always trump any interest that is or political goal that conflict with those rights. For instance, in a case like the drug cases, we can say, if we take this idea of the right to free development of the personality as a right, then we say the goal of fighting drugs is just a policy goal, then this right must win in this confrontation, and for this reason the law must be unconstitutional. This is one way to justify a decision. Another way, let me call it the English way, is linked to the idea of unreasonableness, which is the following. It's more or less the following: is that what the political authorities, they decide that is fine unless it is too unreasonable, that we as court we need to strike it down. There is another way, which is, for instance, the German way, and also the Spanish way, which is this idea of the minimum core. We can, for instance, think that rights, they have many dimensions, they can include many elements, and that political authorities can limit some of those elements, but not the core of the right. The core of the right is untouchable. No one can touch the core of the right. Now, the problem with these ways to justify those decisions is that they are very intuitionistic, and sometimes it's very hard to deliberate about the key concepts. For instance, if we think about rights as trumps, then it means that those rights must be absolute. That is to say, they cannot be limited. The problem is that if we think seriously about that, there are not absolute rights. Even, for instance, we can think about cases in which maybe we can imagine a justification for torturing. If we are sure that by torturing one person that is going to commit a terrorist attack, we save the life of 20,000 people, maybe there is a way to justify that, or maybe a court can find a way to justify that act of torture, or maybe not. We can discuss about that. The second thing, if we use the reasonableness standard, then maybe we can allow, as courts, we can allow politicians to do whatever they want, and the enforcement of constitutional rights ends being a joke. And third, if we think about this idea of the core of rights, then what is necessary to drink or to smoke to see the core of a right? It's very difficult to know, to grasp what is the core of a right, what would be the core of the right to free speech, the core of the right to education, the core of the right to health. That would be very difficult to determine. Now, there is a way in which courts manage to do this in a sophisticated way, and I have to say, perhaps the best book in the market explaining this is this book by Alec and Jed Matthews, which is the idea of the proportionality analysis. And what is the idea behind proportionality analysis is that when we have, for instance, when we as courts, we have to solve a case, we have a general idea is that rights that are entrenched in a constitution or in a human rights charter are qualified rights. That is to say that political authorities are empowered to limit that right. But, of course, there must be limitations to the limitations. There must be limitations to the limitations. And the limitation, the basic limitations, there are, of course, procedural limitations. The authorities, they have ways in which they can legally impose limits to rights, but there are also substantial limitations, and the proportionality analysis makes clear what those substantial limitations are, which are very easy to grasp. The first idea is that the limitation has to have a legitimate goal, then it must be suitable to achieve that goal. Also, the limitation must be the least intrusive alternative to achieve that goal. And at the end, there must be, this limitation must be proportional in narrow sense. That is to say that, to say it in a colloquial way, what we win with the limitation must be higher or bigger than what we lose with the limitation. Then this idea of proportionality came to the field of the legal political ideas in Prussia, and then became a general principle of the German administrative law, and then the German Constitutional Court from the very beginning, from their case concerning pharmacies, began to use that doctrine, and then the doctrine migrated to the whole Europe, to Latin America, to even to Australia right now. The High Court has had a couple of cases in which has used this idea of proportionality analysis, and is becoming very famous also in the area of human rights, in international investment law, in international economic law. Why? Because this way of reasoning is very helpful as a clear, transparent way to decide those cases in which we think about the legitimacy or constitutionality or accordance with human rights charters of rights limitations. Naturally, there have been a lot of criticisms also concerning the way proportionality is used. For instance, people realize that, and this doesn't come to a surprise, that proportionality cannot guarantee a correct answer. Why is that? Because no methodology can guarantee a correct answer. Even the syllogism, if we have false premises, we're gonna get a false conclusion using a syllogism. Indeed, if a court uses incorrect premises to input the proportionality analysis, of course, the answer will be wrong. Now, I have to say there are two, at least in the last year, two pieces, very important pieces of doctrine were published concerning proportionality. One of them is this book by Alec and Jed Matthews, in which they explain why proportionality has been successful as a doctrine that has migrated to many jurisdictions in the world, and also they argue that this doctrine helps courts to achieve the goals of a constitutional system, at least two of them, which is effectiveness in managing the constitutional system and also completeness. And Alec, correct me if I am wrong in your response. And I totally agree with that. I think that this last wave of constitutionalism, this wave puts courts in the center of the scene, and it grants us, for instance, this is what happened in Colombia, supervisory role, a role in which we manage and we have an input in the work of other branches of government, and the way in which proportionality helps us to accomplish this role, it is remarkable and cannot be achieved by any other of these alternative methodologies that we have. For instance, when we let's go back to that idea of the law that relates to the prohibition of consuming drugs in public places. What happened after that is that my colleagues, when they faced that backlash, they managed to explain better the decision and to use proportionality analysis. And then what is going on is that not the Congress, but the majors are actually following up the decision and restricting the consumption of drugs in public parks, for instance, for the sake of protecting children. Then the decision by the court created a dialogue in which there is a way in which authorities comply with the Constitution, and also the people who lost with the decision are getting also protected. For instance, I have two little girls, and one of the experiences that I had after this judgment is that my wife and I, we took the little girls to the park, and there were people using drugs in the park, and we couldn't do anything about that. Now, this situation is changing. Why? Because the mayor of Bogota enacted enacted a decree in which he prohibited the use of marijuana in parks for kids. And now the people who use marijuana can go to other places, and then we can use the park. This is an example in which, for instance, this idea of proportionality helped to manage this dispute between segments of the population that concerning one same issue have different rights. Now, the other thing is that, I think Alec and Jad are right about that, is that in this way, proportionality helps court to have to sustain this effort and this control over the system concerning the adjudication of rights, managing influencing the other authorities to comply with those rights. And this is one thing that we cannot find in the other, with the other methodologies. Now, what I would like to claim, and this is exactly the point of my paper, is that it's the question, it relates to the following question: whether this idea of proportionality is somehow linked to the question concerning the ontology of rights, the ontology of rights. I know that, rights are concepts, and as concepts are abstract objects that help us to understand one social phenomenon. And there is a lot of discussion about the nature of rights. For instance, in moral philosophy, there are people who think there are not moral rights at all. There are other people that think they're actually, for instance, moral rights actually exist. Other people claim, for instance, moral rights exist only as a suggestion for what politicians or legal authorities must entrench in the law, etc. Now, there are many ways in which we can also conceive rights. And I think there is another publication that came recently, which is the Jamal Green's 2017 foreword to the Harvard Law Review, Rights as Trumps, in which he also claims that proportionality analysis must be used in the U.S. Where there is debate in this area, but some scholars contend that U.S. judges are more reluctant to use proportionality than other justices in other parts in the world. Then Jamal Green claims that invites U.S. judges to use this scheme of analysis. And one of his points is that right now we have too many rights that worth less or worth too little in the world. His point is that before, when we didn't have a pluralistic society like our society, we have some core rights, very few core rights, and then in that way it was possible to understand those core rights as trumps. For instance, when we talk about yes or no, the political opposition can express views against the government in a political campaign. Either you have the right and that right is untouchable or not. Now, I can agree with Green that there is a deflation on the meaning of having a right. We are having too many rights. For instance, in Colombia, we have to decide very soon a case in which the matter under discussion is whether a bear has a right to personal freedom. Why is that? Because somebody filed a habeas corpus just to request that we as court, we command a zoo to release a bear. Then the question is whether the bear has a right. Then what is the meaning of the right to liberty if we attribute that right to a bear? We have too many cases. We receive in our court at least around 70,000 constitutional complaints a month, and some of those complaints relate to things that you never thought somebody can relate to a right. You know, the language of rights and this access to jurisdiction implies that rights worth less right now. Now, the point is what is a right? And also whether this migration, this successful migration of proportionality is somehow linked to this idea of a right. Then the person who was my mentor during many years in Germany has a wonder, Robert Alexi is his name. He has a wonderful theory on rights, and he claims that rights are principles, and principles are optimization requirements that require authorities to realize their objects to the greatest possible, and the greatest possible extent is interpreted in two ways. First, legally, that is to say, to the greatest extent that conflicting rights allow, and also factual or empirical in a way, that is to say, in which all the resources we have in society allowed us to grant that right. For instance, if we think about the right to health, we have that right as an optimization requirement that that imposes to political officials the obligation to realize that right to the greatest extent in which the financial situations of a country help us to do that. Now, there is one important thing concerning the theory by Robert Alexi, is that he says that this idea of proportionality is conceptually linked to rights in the following way, that always this migration of proportionality is just a superficial sign that there is a conceptual connection between rights and proportionality, rights understood as principles and principles linked to proportionality, in a way that whenever and wherever there are constitutional and human rights, there must be understood as principles and there must be applied by proportionality. So it's a very strong thesis, very strong claim that is at the core of his theory. Now, my claim concerning that is that this claim is really too strong and is counter-evident. Why is that? It's because, of course, we have many ways to achieve a constitutional decision concerning the limitation of our right that can be sound. It's just by intuition, as justices, for instance, when we sit at the Constitutional Court, maybe, perhaps, we don't know how to explain or how to justify a decision, but the decision might be right. Also, we can use all of the methodologies, and those methodologies can lead us to a decision. And indeed, there have been practices of adjudication of constitutional rights that have departed from proportionality, and those practices are very well crafted. For instance, in Australia, there is a strong practice of applying implied rights, and proportionality is just arriving to the country, and nobody can claim that this practice doesn't count as a practice of constitutional rights. Now, the point that I make in the beginning of this paper that I'm trying to write is that there is a weaker claim that we can make, which concerns the normative necessity of proportionality. And this claim is, I can present this claim or back this claim by means of an argument that it has 3 steps and a conclusion. The first step is the following: it goes in the following way. It is normatively necessary to adopt a means towards an end if 2 conditions met. The first one, this is the best available means to that end, and second, the end is required. The second step is the following. In any jurisdiction, the adjudication of constitutional rights takes place under specific conditions in which judges should pursue certain ends deriving from constitutionalism, deliberative and representative democracy, and the rule of law. Those ends are the following: pluralism, that is to say, they have to take into account all the interests and rights at the stakes of all the different people. Second, transparency, that is to say, they have to show the reasons. Third, granting priority of rights or competing interest. Maybe this priority is not absolute as in the theory of rights as trumps, but there must be some priority. Otherwise, the idea of right becomes senseless. Then consistency, clarity, predictability, and also granting a space of discretion to political authorities. I think those are the constraints that a court that works in a system of constitutional democracy faces. And right now, we have several available standards like proportionality, this idea of course of rights, the idea of reasonableness, and the idea of rights as trumps. And what we do is that we need to compare those alternatives and see which one of them is the methodology that helped courts to achieve those goals in the highest possible degree. And I think Alex's books show clearly that proportionality is the best of those alternatives. Then if this is the case, then while at least until we find a better thing, a better tool, a better device, then we as courts, we have this normative obligation to apply proportionality, and that's what we do in the practice of our court every day. Thank you so much.
Yeah, I think it's probably a good idea. Thank you, Justice Bernal. I think that provides a lot of fodder for further discussion, and I already can think of some interesting lines of questions perhaps that we'll get to. I should remind everyone again that this is simultaneously not just a panel about proportionality and constitutional adjudication, but also a book launch of sorts for Professor Stone Sweet's recent book with Judd Matthews on proportionality, balancing, and constitutional governance, and there are copies available outside. So please pick up a copy if you are in the market for a cutting-edge book in the field. So I'll hand things over to Professor Stone Sweet. Thanks very much.
Well, it's a great pleasure to be here, especially with Carlos. Back before he had such an eminent position as judge, before he was a great justice on a great court, one of my very favorite courts in the world. It's a court that should never have succeeded. It's a court that never should have built effectiveness. It's a court that was doomed to failure by any theory we have in judicial politics. And yet it's become one of the most inspiring, most successful courts. It's taken some of the most brave, courageous decisions of any court in the world, operating in really difficult circumstances. And I've known Carlos since way back, sorry, I've been calling him by his first name. Yeah, way before you became such a, and he actually translated the first 2 articles I wrote on proportionality 10 years ago into Spanish, into a nice book. And so I am incredibly grateful as well as admiring of Carlos. So I want to talk about 2 things. One is I want to talk about a little bit about what Carlos just talked about the necessity. I think I'm going to be much stronger than Carlos about being necessary, and because I don't think this proportionality is necessary for exactly the same reasons that he thinks. Because I think we have to ask a prior question when we talk about necessity, about necessary for what? For what values? Now you've touched on some of them, but the way the book poses it is that what we should care about, what necessary should be for the effectiveness of rights protection. And surely that's what you mean too. It's got to be that. And by effectiveness of rights protection, we defined effectiveness of a system of constitutional justice as having 3 components. The first is that the important questions in a society come to that court. Second is the court authoritatively resolves those questions and produces a jurisprudence, produces a set of justifications for why they came up to the decision that they did, and that is curated as a case law, a binding case law. And the third element of effectiveness is that, and this is, for me, as a political scientist, the most important, and Carlos is going to be talking about this in a couple of days, is that it has to induce all of the other power holders in the system to think about that case law as binding on them and their own policymaking. In other words, if it doesn't create the kind of constitutional dialogues that we deal with in Chapter 5 here, and that Carlos is going to talk about in a few days, the court is going to fail. The court is going to fail. And if we fetishize just the court, and we don't look at how the court interacts with the other officials, you're going to miss a big part of what's going on. So I'm going to skip a little bit about what I had to say here. I don't know if I can figure out how to use this. I'm going to skip stuff because I really want to focus on what Carlos said. So I want to I'm going to simplify a lot. For any sophisticated person in the room, meaning all of you, you're going to be dissatisfied with what I'm going to say. But that's because I want to go fast, and I only have a few minutes. And so I want to start with a very idealized version that's developed in Chapter 2 of the book of a system of constitutional justice. Now, a system of constitutional justice is that complex of constitutional rules, principles, procedures, and practices that govern the enforcement of the Charter of Rights as higher law. So what we care about is an entrenched constitution that has a Charter of Rights in it and a court that has whose mission it is to enforce that Charter of Rights against all other lawmakers and law enforcers. That's my unit of analysis in this book. And what we care about is how do we get to effectiveness? Okay, if we look at we think about a model of constitutional justice, we think about modern constitutional law, we see that the Charter of Rights is absolutely central. Not only does it come at the beginning of most constitutions, but it actually is almost a complete constitution in itself. And why is that? It's because most of the rights that are in it are qualified rights. That is, the Constitution itself pre-authorizes government, state officials, to limit, abridge, infringe upon rights when done for a sufficiently important public purpose. That is, the Charter of Rights tells you what the constraints are on government. It also says, here's what you can still do that. So you don't really need the rest of the Constitution in certain ways. You need the Charter of Rights, and then you have these qualified rights. Qualified rights are those that are qualified by a limitation clause. They give you a right, and then in the very next sentence, usually, very next sentence will tell you, well, but this right is not absolute. It can be abridged for various kinds of reasons. So one way of thinking about this is that rights establish, I hope Carlos agrees with me, this, binding positive requirements of validity. Okay? So that raises the question, well, how do we enforce those binding requirements of legal validity? Right? Any act that violates the Charter of Rights is invalid, must be illegal. And it's the Constitutional Court, of course, which enforces that Charter of Rights, or more technical, I think better, adjudicates the limitation clauses that are in the Charter of Rights. And two further elements are strongly applied if not necessary. I put if not necessary before I knew what you were going to write, so I'm on your side about necessary. Individuals must have a right to justification. That is, to the extent to which they can challenge, any individual can challenge any act that infringes their right, their general, even including general liberty, any act of general liberty, however crazy it sounds, as Carlos just said, to the extent to which they have that right, the extent to which we get more completeness. And an effectiveness will be related to completeness. And the court must be positioned to scrutinize the government's justifications for infringing a right. All this might seem very obvious, but it produces very powerful functional demands. If you have a charter that's conceived as establishing binding positive requirements of validity, then that begs the question, how the heck do we enforce those against the rest of the rulers? If you have the court must be positioned to scrutinize, how do they scrutinize? These are powerful problems. So in this model of constitutional law, individuals possess a right to just governance. There's a beautiful book by Jacob Weinrib on dignity and also on what he calls modern constitutional law that develops this theme. Rulers possess a right to rule, yes, but only as far as they do not violate the charter. Again, we have this functional problem. Okay, how do we determine whether or not they've violated the charter? And the Constitutional Court, of course, monitors the ruler's compliance with rights. And I'm going to get to this in a minute. The necessity of the proportionality principle is that that's how they do it. Now, why did they do that? Now, Carlos wants to say it's a necessity. And I want to say it's not what's necessary is not proportionality. What's necessary is you fulfill a certain number, three, I'm going to mention three, strong functional demands. The proportionality solves these problems. But the problem is what drives this necessity. I've mentioned some people who share this basic framework. By the way, they're virtually all Kantians. So so this is talk about necessity, Carlos. So what is necessary is not proportionality, but it's more generic in my view. So what is necessary is we need to have a stable framework for judicial scrutiny of justifications for limiting qualified rights, right? You would agree with that. We'd have to have a stable or some framework for judicial scrutiny of those justifications proffered by state officials for limiting rights. And this flows from the structure of rights. This is Alexi. I completely buy into Alexi's ideas of rights as principles and his optimization requirements, and Chapter 2 lays that out. Those of you whose eyes are already glazed, read the book. Don't bother reading Alexi. Read Carl. Alexi's really hard, but he's necessary to understand this part of it. But what's important for us as more lay people is that if we have to scrutinize these justifications, if that's what a Charter of Rights produces, a positive obligation on the part of state officials to justify in every case in which they abridge a qualified right, then we have to have some way of doing so. Proportionality fills that need. That's the way I would put it. It's slightly different than Carlos, but it's not really. We're just playing semantic games. The second reason is that if rights are positive requirements of legality, then and indeed, if proportionality is institutionalized, rights and proportionality become a criteria of legal validity and legitimacy writ large, right? It's not just about adjudication anymore. It's about producing all public law and to some degree, private law has to conform to the proportionality principle or be invalid. I think you would agree with that as well. So that raises the question, how do we operationalize a positive requirement of legality conforming to this charter? And proportionality does that. Every public act that infringes upon a right must respect the proportionality principle or itself be invalid. Right? So the proportionality allows us to operationalize that positive requirement of legality. And third, this is a strategic and political point. Carlos raised it, though. He has to raise it because he's a judge. That is, I have to worry about my long-term survivability. And the way that courts worry about that, the way that courts respond to these crises of legitimacy that are regularly going to be created by doing robust rights protection, is by justifying their rulings, right? So if the second point about rights being a positive requirement of legality gets us back to this problem, the problem with rulers possessing a right to rule, we have to have some means of securing the accountability of public officials, right? Proportionality plus a right to justification give us that means. The third one, though, but then if we elevate constitutional judges to be the high priest of our Constitution or the supreme interpreters and enforcers of our Constitution, then the problem of accountability of judges comes up. And of course, courts have to justify their rulings, or Carlos says that that's the only way we can do it, is to produce defensible, transparent justifications. And of course, this is the great secret of proportionality. Proportionality furnishes a simple, easy to teach. It's incredibly easy to teach. I can teach students how to do a proportionality moot in 2 hours. You know how long it would take me to teach them even part of First Amendment doctrine in America? Because every time you move from one kind of speech to another, you're in a completely different web of doctrinal rules. Proportionality is trans-substantive. You move from one right to another right to another right, and you're using the same you're marching through in an unbelievably boring robotic style. It gets exciting later, but the tests. It's easy to teach, and it provides a framework. It almost automatically provides a complete, comprehensive, transparent framework for litigants, for counsel to plead their cases, and for judges to package and justify their decisions. That's ultimately, I think, the great secret. You always know, the judge is going to have to make a decision, and we can all criticize it, but at least we know when they made their decision for what reasons, when they jumped off the cliff. In America, I can tell you, you hardly know half the time. You got 6 decisions already. You got 20 streams of doctrine coming together. It's incredibly difficult in many, many cases, especially with the 3 levels of scrutiny and so on, to figure out what the hell just happened when they're done. So the upshot is, in my view, that the reason proportionality is important, ultimately, is because we care about effectiveness of rights protection. It's not because proportionality is necessary in and of itself, but I agree with Carlos that it serves these interests. It allows us to scrutinize justifications. It allows us to be a servant. It allows you to be a servant of accountability for officials, and it allows us to hold you accountable. So that was my little riff on what you had to say. So the rest of my time, I want to very quickly talk about the empirical parts of the book. So what I just talked about is chapter 2. It's dense, it's technical, it's probably not fun for anybody to read. But the rest of it is kind of fun in its own way, because what we did with the book, we wanted to chart the diffusion of proportionality to the courts of the world. Because at this point, virtually all of the most powerful courts in the world, at both the national and international level, have adopted proportionality as a constitutional principle. The EU court does, the ECHR does, the Inter-American Court of Human Rights does, 3 African courts, and they use that word constitutional. And yet, and it's important to remember, proportionality is a unwritten judge-made principle. It's an unwritten judge-made principle. So what we were interested in is what did the dynamics of diffusion of proportionality look like, and how did judges justify that move? And then third, after they've adopted proportionality, what effect does that have on the greater policy-making environment? Does it actually impact the state officials, like legislators and executives and ordinary judges, does it actually alter the way they do their business, the way that they make their decisions? So basically, you can see this PowerPoint thing is useful for this kind of stuff, right? So there's a lot of information there. I'm just dividing it very simply into 3 waves. What's interesting about the first wave, which is Germany, the EU, the European Court of Human Rights, Canada, and GATT WTO, is no judge justified the adoption of proportionality. They just announced it. They just started using it. And later on, after a decade, in 2 decades in Germany's case, and shortly thereafter in the International Court's case, they said that it was a general principle of law. And then they said it was a general principle of constitutional law. Okay? So it got consolidated as a constitutional principle of law. And that's really important. So it's one of those general principles that allows, there are many, but one of those principles that allows judges to build their own court systems. It's an architectural, foundational element of constitutional law today. In the second wave, all they did was cite to the first wave, right? So that's another part of the secret, is that judges always looking for authority would just cite to other judges who wished there were authority but didn't have it. So and then you see this is South America basically, and Asia. This is part of the second wave. In the third wave, since probably the last 10 years, last 12 years, all these other courts, the Inter-American Court, Mexico, Brazil, Chile, Peru, the 3 African courts, Zimbabwe, Kenya, so we're making inroads into Africa as well, Tanzania, Malaysia last year, it's treated as a best practice standard. Any court that wants to prove its bona fides as a rights protecting court has to do proportionality. The burden is on you as a court, as a judge, why it is that you're not using it. Certainly you can't use Wednesbury reasonableness. It's abdication. It's not even a rule of law. It's a denial of a rule of law from the point of view of proportionality. And that's one of the reasons why Hong Kong, and a place like where I live, Singapore, which has no business doing this at all, I mean, they've written rights out of the Constitution through a Wednesbury reasonableness kind of test. But from our point of view, I'm going to talk to you, it's completely illegitimate. It can't be legitimized under any notion of constitutional rule of law under modern constitutional law. Of course, you can say we're not going to be governed by modern constitutional law. In many ways, the UK is still not, as you can tell if you watched the TV last night. And the other amazing, the judges then cited the first movers, Israel being a very, very important case because proportionality came to Israel through our own Barak. Barak then wrote a treatise on proportionality. It was published in 2012 by OUP. That book is cited by everyone. Every single court in that third wave cited to Barak. It's quite extraordinary. So here you see the power of judges who write this unwritten rule in their decisions, and then that unwritten rule becomes codified, essentially, standardized, rationalized through Barak, through a treatise. And then last, I'm not going to talk a lot about this, but codification. Most newer charters of rights, in fact, have the proportionality requirement built in. They just simply write it now. So now it's positive law, positive written law, not just a. And then last, I'm going to skip this. A big part of the book is about how courts use proportionality differently, but how gradually there's been more and more convergence. Carlos sits on a court that uses it in all kinds of inconsistent ways. Yes. But it's interesting. I think Carlos, one of his goals, I'm going to talk to you all day. We've never talked about it. One of your goals, I hope, is to get your colleagues to try to use it in a more consistent way. So, but that is happening, and one of the reasons it's happening, of course, is because of Barak. Barak has spent his 500-page book telling judges basically how to separate the different stages, because the judges are always mixing stages. And one of the interesting things is political, is that every court that we looked at that's powerful today started out not wanting to use too much balancing. They wanted to stay with either necessity, which is least restrictive means, or with suitability, rationality. And they would bring in balancing elements. Canadian court is one of the most famous ones. But the Canadian court has now cleaned up their house. And one hopes that this kind of standardization will continue. And last, I only have one last thing to say. I already talked about this a little bit, so I won't go on about this. But it's about constitutional dialogues. one of the things that proportionality does, it doesn't require judges to do it, but it enables judges to do it, and all skilled judges who use proportionality seek to construct constitutional dialogues with those they control, like legislators, administrators, and other judges. And that involves, as Carlos mentioned, ensuring that there's enough deference left for there to be meaningful policy, discretion left, for there to be meaningful policy discretion for them. And what judges do, here's a way of thinking about it, this is a Barak way of thinking about it, what we do as judges, we delineate the zone of proportionality within which you're free to choose all kinds of policy points. But we also say what you can't do. Outside of that boundary of the zone of proportionality, you can't move there. So almost all decisions, the good decisions that are dialogic decisions, do things like you cannot do what you did, if they're going to spank the legislator. You cannot do what you want to do, but because you've harmed the rights holder too much. And you could do that either with less harm under necessity, or you can reduce the protection you want for whatever value you're doing in order to enhance rights protection. And so what you have to do, what you do in those kind of situations is you make sure that you give guidelines for how to revise your law, to correct your law, to make it proportional, and oftentimes you give deadlines. That's a really wonderful thing the Germans invented, which is to say, this is disproportionate for these reasons. And to make it proportionate, you should make sure that here's a checklist of things you must do, and you get 1 year to do it. Or you get 2 years to do it. Or you get 6 months to do it. And if you don't, we're going to strike it down, which will almost always involve with judge-made rules. So that is now some people would say, Jeremy Waldron included, that this is not dialogic, because ultimately the court is dictating in a certain way. The court is a lawmaker in a certain way, and the parliament, for instance, is a law taker. I disagree. I fundamentally disagree. But it's not built into proportionality. It's something that judges have learned to do strategically to ensure their viability. Right? The Constitution. So I'll just repeat the one and stop. That judges who are not good at creating, instigating, sustaining constitutional dialogues will fail. And I think that's exactly what you're going to be talking about in a couple of days, right? So thank you.
Thank you very much, Professor Stone-Sweet. I can actually really relate to your comment about the mess that used to be the Canadian Supreme Court's proportionality jurisprudence. I'm envious, actually, of law students today in Canada, because when I was a youngster, it was still pretty confusing for us, even though on the surface level, it looked like an easy to teach, easy to learn kind of system. But when we were trying to make sense of its application, I remember struggling with that. So we are lucky to have two colleagues from HKU, Faculty of Law, Cora Chan and Pojan Yap here. So I guess we'll begin with some commentary from Cora. Thanks very much.
Thank you very much, Justice Bernal and Professor Stone-Sweet, for two very insightful and stimulating presentations. I'm immensely honored to be able to be a commentator on this panel. I've got about 10 minutes, and I've been invited to focus on Justice Bernal's presentation, but in the course, I think some of my points might apply to Professor Stone-Sweet's arguments as well. In addition to Professor Stone-Sweet's book, I've also had the benefit of reading Justice Bernal's article in the New Zealand Journal of Public and International Law, which I think provides a more elaborate version of the argument that you just gave. So part of my response will be to the arguments in that paper. So Justice Bernal presented a normative case for the migration of proportionality, and in doing so, he first presented an abstract case for the use of proportionality in constitutional rights adjudication. And then he moved on to explain why proportionality is immune to the common objections against constitutional migration. I'm much persuaded by his positions on both issues and only wish to add a few small points to supplement his case. On the first, the abstract case, he doesn't rely on there being a conceptual necessity between proportionality and constitutional rights. Instead, he argues that there is a normative necessity. Proportionality is a juridical tool for resolving clashes between rights and public interests or other rights, that best adhere, a juridical tool that could resolve this clash, that best adheres to certain principles derivative from constitutionalism, rule of law, and democracy. And he's just explained what those principles are. They're pluralism, transparency, predictability, non-arbitrariness, respect for the separation of powers, and priority of constitutional rights. In other words, proportionality is a solution to common problems in jurisdictions that share these values. A lot of the arguments for proportionality being the best tool for adhering to these values rely a great deal on the fact that proportionality has a well-defined structure. This structure is able to funnel relevant considerations into their appropriate context. It encourages both the government and the courts to reason transparently, and it enables the two to dialogue on specific issues, etc. I have 4 points to make. First, structure is not inherent to proportionality. While some tools are indeed inherently less able to channel all relevant considerations into their appropriate context. For example, definitional balancing. I agree that it's very difficult to come up with a structure for definitional balancing, categorical balancing. My view is that proportionality is not the only tool for which structure can be developed. One can imagine developing a structure for reasonableness as well. And I'm not thinking of the extreme Wednesbury unreasonableness of English law, but just the concept of reasonableness. And Paul Daly has attempted to give it structure by identifying certain indicia of unreasonableness. Having said that, it is true that proportionality, as developed over many years and applied by numerous jurisdictions, has come to acquire a well-defined structure that its alternatives lack. Also, various doctrinal methods have been developed for implementing that structure in proportionality, which, again, its alternatives lack. So if we already have a structure that works, or that is, in Professor Stonesweet and Matthews' words, well-tested, a structure that is a best practice standard, then there doesn't seem to be any reason why we would need to develop a structure for an alternative legal standard. Not to mention, I think it's both of your argument that proportionality is a more suitable standard than other standards in the adjudication of constitutional rights. So my remark here doesn't affect the strength of the abstract case for proportionality. All I wish to highlight is that there is no inherent connection between proportionality and structure, and no inherent disconnection between structure and at least one other standard, i.e. reasonableness. Second, likewise, transparency in reasoning, transparency in explaining decisions, proffering of public reasons to justify a decision, these are things that are external to proportionality. If the court or a government is willing to explain its decisions using public reasons to justify the proportionality of a decision, that is due to them willing to adhere to a culture of justification, and due to them willing to put the burden of justifying a prima facie rights limitation on the government. Both of these, the culture of justification and the burden of justification, are extrinsic to the tool of proportionality itself. The courts and public authorities in jurisdictions that adhere to a culture of justification and puts the burden of justification on the government could be equally serious in justifying their decisions with public reasons, in using, say, the reasonableness standard. And likewise, in jurisdictions that don't have the culture of jurisdictions, or where the burden is vested with the litigant, even if proportionality is adopted, courts and the government may still be non-transparent in their reasoning. Proportionality, in other words, it's a legal standard that we expect the government to meet. It is distinct from the burden of justification. It is also distinct from the background culture or the rules governing reasoned justification. Whether the application of proportionality will encourage transparent and rational deliberation by judges depend crucially on the latitude rather than the legal standard itself. But having said that, Having said that, the spread of proportionality worldwide is indeed concomitant with the spread of a culture of justification, and in jurisdictions that adopt proportionality in rights adjudication, indeed the burden of justification is placed on the government. And this is not an accident. The imperatives of constitutionalism, the values of constitutionalism that lead to the adoption of proportionality also naturally lead to quote Professor Stonesweet and Matthews, a mode of governance that requires reasoned justification from authorities for limiting rights. So my point really here is that conceptually, the legal standard, the burden of proof, and the culture of justification are distinct. Third, proportionality itself doesn't contain an inbuilt tilt in favor of rights, so it alone doesn't guarantee the priority of rights. The tilt comes from outside, the special weight given to rights when they are input into the proportionality formula. As numerous scholars have argued, and I think it is a point that both speakers accept. On its own, proportionality is perfectly compatible with rights being given little weight. But again, in jurisdictions that apply proportionality, rights are usually given special priority. My point here really is that the fact that it's been deployed to prioritize rights is due not to the tool itself, but to the background culture that treat rights as important. So far, the points that I'm trying to make is that a lot of the advantages of proportionality come not from the tool itself, but from the culture and practices of constitutionalism that these jurisdictions embrace, as well as the surrounding doctrine that was developed through, to quote Stonesweet, through an ongoing macro process of diffusion and legitimation that has occurred on a global scale. So for proportionality to be able to deliver these same advantages in receiving jurisdictions, it is necessary either for the receiving jurisdiction to already embrace these supporting elements, or if not, for these supporting elements to be transposed as well. In most cases, this wouldn't be an issue because, as I said, the imperatives that lead to the adoption of proportionality would also naturally lead to the adoption of these other practices. Fourth point, the 7 values that Justice Bernal mentioned can be in tension with each other. For example, respecting the separation of powers may conflict with predictability. In order to respect the government's institutional competences and legitimacy on rights issues, courts may have to, and they have granted deference or margins of appreciation to government authorities. This idea of deference, especially the contextual approaches to deference that courts now tend to apply, has rendered the application of proportionality much less predictable than originally envisaged. And in fact, the proportionality test has at times been diluted to beyond recognition. And ironically, the need for contextual deference around the world only became more acute after the relatively stringent standard of proportionality has been introduced in rights adjudication. This objection it doesn't affect the strength of your argument because from experience, the need for variable standards in adjudication would arise even if other standards are applied. For example, if courts apply a standard that is inherently less demanding than proportionality, for example, in the pre-UK Human Rights Act era, the UK applied the standard of reasonableness. Even if they apply an inherently less demanding standard, they may need to increase its intensity of scrutiny when more stringent scrutiny is called for. So there will be a degree of unpredictability as long as we want the level of judicial scrutiny to suit the myriad of contexts in rights adjudication. What I'm saying here really is that the application of proportionality may not be as predictable as one would expect. My final point is that Justice Bernal presented a persuasive case in the paper on why migration proportionality doesn't suffer from the usual problems of constitutional migration, and I agree very much with it. I would only add 2 points. First, the migration of proportionality doesn't harm democracy or local traditions precisely because it is an empty vessel. Proportionality has been criticized as an empty vessel, or what Stone Sweet would call a substantive indeterminacy. But it is this very empty, this indeterminate or empty quality is precisely what makes it versatile. It is able to accommodate the different values determined by history and traditions of particular jurisdictions. And my second point is that the other argument which you raised for the versatility of proportionality is that it can be applied with different margins of appreciation. I agree, although I would also like to flag that we shouldn't assume that proportionality could be varied or should be varied infinitely. The fact that it has been applied with infinite flexibility doesn't mean that such degree of flexibility is justified. I've argued elsewhere that to preserve the logic or integrity of proportionality and the culture of justification, there are limits to how variable the test could be. Thank you.
Thank you. It's a privilege to join on panel with Justice Bernal and Professor Stone-Sweet and my colleague Cora to celebrate the publication of this book. I think it's available outside. Proceeds will go to us. Just kidding. All right. So I would just focus my presentation on my commentary on this book. So we live in an age of balancing, an era where national courts around the world are empowered to independently determine whether legislatures' limitations on rights are justified and to invalidate laws that are not. Proportionality, or PA, as Professor Stone-Sweet calls it, has emerged, right, as an umbrella term used to reference the different ways conflicting interests are balanced and evaluated by the judge. And in his book with Judd Matthews, they painstakingly show how even though PA has originated from Germany, it has not remained a European produce. PA has been locally transplanted across Anglophone nations, example Canada and New Zealand, mixed legal systems that are rooted in the common law, Israel and South Africa, and even parts of Latin America and Asia. Since we are in Hong Kong and we are living in Asia, my presentation today would focus on Asia. And in particular, I wanted to talk about this. It's the idea that, interestingly, and I don't think it's a matter of coincidence, in Asia, the only jurisdictions that apply structured proportionality is Hong Kong, Taiwan, and South Korea. And what I mean by structured proportionality is proportionality has that form, the four-stage form that Alec talks about, plus in substance, they use that form to strike down legislation routinely and regularly. Some countries don't even have the form. Singapore, where Alec works at, Indonesia, Japan. Some have that form but have no substance. Thailand and Malaysia. Right? So the question is, why do these three, of all the countries in Asia, why do only these three jurisdictions have structured proportionality, the form and substance of PA? Right? And one of the arguments I'm making in the monograph I'm writing is that only in these three jurisdictions in Asia do you see fragmentation or significant fragmentation of political power in the political branches of government. In Taiwan and South Korea, what you have is a dynamic democracy, a competitive two-party system. When you have competing political parties taking turns to hold political office, you will have judges that are insulated from the punishment of one court. From one party. But interestingly, right, this fragmentation of political power can also occur in a dominant party democracy, like Hong Kong. Even though Hong Kong, most of the members of the Legislative Council, and even though the chief executive, right, is primarily pro-Beijing, there is significant fragmentation in how the Legislative Council is constituted. due to the presence of independent lawmakers, due to the use of proportional representation, due to all the corporate representatives that often enough, right, in the FCs, their political interest will not align with the ruling government. And in all these instances where the Hong Kong government do not have control, or in instances where Beijing do not have very strong views on, that provides the courts with significant political space to rule against the government. So moving to first South Korea, since I think many of the members of the audience will probably be watching Korean dramas. The KCC was established by the 1987 Constitution, which expressly reputed autocratic politics and introduced into South Korea a system of open elections and accountable leadership. KCC is a classic Asian example of what Professor Stonesy calls a trustee court. The people have placed their freedoms upon judges in trust as stewards of a right-based regime. With weak political parties as cardinal features of the country's modern electoral scene, right, the KCC was able to assert its authority swiftly and ushered into South Korea an even more liberal model of democratic diversity, right? Notably, the shelf life of a party in South Korea is 5 years. Every 5 years they collapse and a new one is formed. Imagine if when the political scene is that fragmented and when different people take turns in office, right, the courts become really powerful. So since the four-stage PA was established in Korea in 1989, the KCC has imposed tangible cost on the government of the day and introduced significant socio-political reforms. In 2005, the court upended a patriarchal law that subordinated a woman to her father, her husband if she were married, and a son if the husband were deceased. Remarkably, the KCC held that this preservation of patriarchy was not a tradition, was not a legitimate aim for the government to pursue. Stage one of PA. Right? Most recently, in 2018, the KCC held that the mandatory jailing of conscientious objectors to the nation's compulsory military service was a violation of step 4, right? And step 3, and they had to find other means of providing all these conscientious objectors a way to serve the nation without putting on a uniform. And another interesting case, there was a blanket ban on abortion in South Korea, and the court also ruled that this virtual ban, that in all circumstances a woman may not be allowed to have an abortion, is just not reasonably necessary to protect the life of a fetus. Taiwan. While Taiwan remained under martial law, the council was largely a handmaiden of the Kuomintang, because the council was not conceived as a trustee court. But it became one, right? When power fragments, when the nation democratized, with the lifting of martial law, with the election of the president, with the election of the legislative council, the TCC gained policy space to assert itself against the ruling administration. Like its South Korean contemporary, the TCC has deployed PA to initiate socio-political reforms that the government didn't like, often concerning cross-strait tensions. For example, the Taiwan government had a law that allowed it to detain and deport persons from the mainland that entered Taiwan illegally. But the court said that even though you may have national security concerns, the fact that it was indefinite detention, right, undermined your aim of providing a speedy resolution. So the law was struck down on step 2. Similarly, previously, Taiwan's legislation prohibited parents from adopting children from the mainland for national security reasons, arguably. And the court said, no, you can do that, but it is unnecessary to even prohibit persons from adopting mainland children of their own spouses. So with the rise of SP, often as a natural consequence of legislators, while SP can often arise as a natural consequence of legislators creating trustee courts, this is not the only way SP is birthed. While the KCC was conceived as a trustee court, the Hong Kong CFA and the TCC were not. Both courts were originally established for dominant party regimes. Such autocratic regimes were in no danger of losing power, and they were not seeking to insure against some political loss. But over time, as power fragments across separate political institutions and governments become divided, then judges gain political space, policy discretion, to use Alex's term, to independently rule against the government. So SP develops over time as a doctrine of choice for this new judicial endeavor or adventure, as you may call it. Hong Kong, right? What we see in Hong Kong is really interesting. You see the courts closing ranks with the government on elections, closing the ranks on the national flag using PA, but it would rule against the government on gay rights, on bankruptcy reform, on social welfare. Issues that the local government may not agree on the merits, but they will hold their nose to enforce, because all these issues are not crucial to Beijing. So Taiwan, South Korea, and Hong Kong are unique insofar as their courts are the only one in Asia that have converged on the use of SP. The judges reason through the SP stages sequentially and deploy SP to strike down legislation routinely and regularly. This convergence on SP in East Asia has enhanced judicial power, and correspondingly, I think in the words of Professor Stonesweet, made a right-based model of constitutional justice more effective. So what I think Professor Stonesweet and Judd Matthews have done is to show how a global infrastructure on rights would slowly take shape. Not top-down with an international government imposing transnational norms, but bottom-up with a polyarchy of independent trustee courts adopting PA as a general principle of rights adjudication, treating one another's precedents with mutual respect and rendering cosmopolitan justice in the absence of a global state. For that, I think the book will be remembered by history as one of the early books heralding the dawn of this new constitutional age. Thank you.
Thank you, Professor. Yep. We have, I think, some time now for both of our speakers to offer some sort of responses to the commentary. So if Justice Bernal, if you'd like to say a few words in response to anything you've heard so far.
I think I would like to concentrate in a couple of points raised by Cora. The first one concerns this idea of structure, transparency, and priority of rights. And of course, I agree with you that we can have the same structure and call it otherwise. For instance, I have written a piece with a colleague from South Africa, Sandy Liebenberg, who wrote a wonderful book on reasonableness in the area of economic and social rights. And in a chapter of that wonderful book, it's a book of 2012, she outlines a structure for reasonableness that is exactly the structure of proportionality. Then it doesn't matter how you call it. If you have the structure, then we're fine. Then we're fine. Now, the point is it goes deeper to the points of the priority of rights. Having that structure that Po Yen Yap was talking when he was mentioning when he talked about the structural proportionality, and the point of giving reasons. And for that purpose, let me illustrate my response with a case that we heard at the court, a case in which I was the drafting judge. It's a difficult case for proportionality because it's a case concerning economic and social rights. A student attending a law school in a public university, she cannot hear, she's deaf. And then the university provide for her one science translator, but she is requesting three things. The first thing is that she's requesting that that translator must be a legal scholar. The second thing that she's requesting is that is an additional translator. Why? Because they have to attend the university at least 6 hours every day, and she claims this translator gets tired very easily. And third, she's requesting for all professors, all instructors to consistently use slides. Okay? Then, what do you do with a case like that? One possibility is just saying, look, if you don't have the priority of rights, and I agree with you, there is a connection, a conceptual connection between proportionality and the priority of rights. If you don't have the priority of rights, then you just focus in the decision made by the university, and you say, that's it. Those are the university rules. Now, we have the priority of rights. Then we need to take this claim that is linked to the right to education seriously. And then we make an ideal dialogue or a imaginary deliberation between her claims and the reasons that the university can invoke with regards to her claims. Then this is linked to both points, structure and the idea of giving reasons. If we go to structure, then we can use some of the other alternatives methodologies that we have. Then one idea is the minimum core. Does belong to the minimum core of her right to education to have all these three things? Difficult to determine. Now we go to the thing. Is unreasonable for the university to just have one translator? Yes or no? It's a matter of yes or no. Or we can use proportionality. And there is in this example, I think we can show how proportionality helps. Then, for instance, the idea of having all instructors using slides. Is there a legitimate goal that justifies instructors not using consistently slides? Maybe not. Maybe this also helps the university to improve the quality of the education. The only thing we can imagine is the freedom of expression by instructors. But in this case, if we go quickly to the proportionality in narrow sense, for them it's just a small effort. For the students, means a lot. For this problem is solved very easily with the proportionality. Now, the point goes to the translators. Now, the university already provides one translator. Is there a justification for the gap between using two translators and one translator? Maybe yes. And we issue some orders to get evidence in this case, and we found out that every hour of a sign translator is very expensive, and second, it is not very easy to hire a translator that is also qualified as a legal scholar. Then, for this reason, we ran the proportionality structure. We found out that, first, there is a legitimate goal in the university's refusal to hire another person, keeping the finances of the university, blah, blah, blah. It's very difficult to think about an alternative measure, and then it was disproportionate for the university to grant her with this second translator just to her. Then, within this structure, we can see the priority of rights and also why we as court, we need to engage, and also some of, when I issue the first order of response of, the first command to the university to reply to my questions, I already structured the proportionality test so the university could give me the relevant reasons. And this is why I think the proportionality test helps. Now, my final point is concerning this point of predictability. And of course, one thing is the proportionality test as such, And then the other thing is, for instance, the practice of its application. I think Alex is right when he claims that my court is one of the worst in the world using a consistent proportionality analysis. And I can tell you the reason. I was indeed called to discipline by my president and also my colleagues, because my court mixed the proportionality reasoning with the proportionality analysis with the different levels of scrutiny of the American tradition. Then they killed the test. Why? Because I asked him, then tell me, when do you use the strict scrutiny? In every case when we have constitutional rights at stake. Well, we have all cases in which you have constitutional rights. When do you use the rational basis test? When we have financial implications. Normally, we have financial implications in all cases. Then they kill the test. And of course, I agree with you, this practice is not stable. But one thing is the test as such, and the other thing is the practice in each constitutional court.
I'm going to pick on Professor Chen a little bit, too, because I loved what Po Jinyap has to say. Fits right in with my book. Look, I just simply think proportionality is a formalization of reasonableness. Reasonableness was incoherent, didn't mean anything. And we're not talking about Wednesbury reasonableness. If you take reasonableness seriously, then, take necessity. Why would it ever be reasonable for a government to harm a person more than is necessary to achieve a public purpose? You could try to make the argument that should be reasonable, but I think it'd be pretty hard. So, and then I just one set of comments to make about the procedure being empty in prioritization. So, yes, the procedure is completely empty. I don't think you can criticize it for that. I celebrate it for that. That's not where the action goes. It's an analytical procedure. It doesn't tell what matters is the values that judges bring to a particular case. The proportionality test, for those who haven't read a lot of these cases, doesn't tell judges how to weigh the interests. Doesn't tell judges what's important and what isn't, and whether or not free speech is important and for what kinds of reasons compared to other sorts of rights. Judges have to have their own conscience involved, but they also have to have their finger on the pulse of the nation. They have to take the temperature of the country too. So it allows for that. Does it prioritize rights? Here I think I would disagree with you fundamentally, but for a reason I don't think you brought up, and I think you'd probably agree with me when I get done. I'm always telling people they're going to agree with me, right? So it doesn't prioritize rights, but I think formally it does. As a formal matter, as just a strictly formal doctrinal matter, once a prima facie case has been made and accepted by the court, the burden of justification does fall upon the court, and the rights holder bears no such burden at all until we get to balancing. That's a heavy burden. It's a burden that's just plain formal. It doesn't mean that the judge can't relax that burden in various ways. The proportionality analysis is not, and it's diametrically opposed to any kind of formal deference doctrine. But deference can be built into it in the ways that judges apply it, if you will. That's how you said it. Apply it by the way that they give weights to different kind of values. But the bigger point is that the argument that we make is not that proportionality test is inherently rights prioritizing. It's that a court that wants to rights prioritize better use it. That it offers a lot of advantages to those courts who want to build effectiveness compared to other procedures. It doesn't mean that they're going to. There can be all kinds of judges who don't adjudicate in good faith, lots of them, or who don't understand proportionality, don't use it right. But if you are going to, what your job is, if you take it as your mission to enhance the effectiveness of rights, there's just no other game in town, frankly. And I would say, and here's the one part that I think we disagree on, that what you did in your presentation, partly, was detach proportionality from its constitutional environment. And I would want to embed that. Remember that in most of these cases, the Constitution already prioritizes rights. It already puts the Charter central. It already says the Charter of Rights is hierarchically superior to legislation. And it already makes constitutional courts like this, creates them and gives them as their fundamental mission to prioritize rights. So if they're not prioritizing rights when they use proportionality analysis, they are abdicating their role. They are negligent. They are constitutionally criminal. Negligent. So we can talk about judges not doing their jobs, but if they're doing their jobs, then they have to prioritize rights protection. Optimization, of course, in various ways. So I think that we can't talk about proportionality just as an austere version of 4 steps and analytical procedure that's, as you say, empty. We have to remember that this proportionality test is embedded in a bigger culture of, and then last, you want to separate out, and this is a good conversation that we'll continue to have for many years, I think. You want to separate the culture of justification from proportionality. Well, the countries that adopted this didn't have that culture of justification before. There's no ex-ante culture of justification that's just out there. It's built. How was it built? Through constitutional adjudication and proportionality. That's my view. Because in most of these countries, there was prohibition of judicial review. None of them had histories of judicial review or rights review. So where did that culture of justification come? There was no accountability mechanisms. There was no judicial power to hold executives and legislators accountable. So I think that if you think it's really important, and I agree with you on this, that the culture of justification is there and it helps sustain a court like Carlos's court, we have to ask the question, where did that culture of justification come from? Right? And I think a lot of it's come from this turn towards modern systems of constitutional justice. And last, you two are both, as I understand it, going to be doing longer-term projects on proportionality and constitutional governance. And I know for sure you'll go a lot farther than we did, so I'm looking forward to that.
2 questions from